Ontario judge has restored the defense of extreme intoxication in sexual assault cases. This comes after a judge ruled that a federal law removing it violates the constitutional rights of those accused. For more on this and what it means for the legal system, let's bring in Ari Goldkind. He's a criminal defense lawyer, and he joins us from Toronto. Thanks for your time today.
Good afternoon, Beverly.
So tell me a little bit more about the case. It argues, in essence, that extreme drunkenness is a defense now in committing sexual assault. Walk us through this.
Sure, and it's really confusing to a lot of people, but let's try and keep it as simple as we can for now. In 1994, the Supreme Court essentially said, if you're in an automaton or robotic, to use an easier to understand term condition, even due to your own drinking, this is important, to doing it to yourself, if you're in that kind of extreme state, you may get a pass, a get out of jail free card for an important crime in our criminal code, particularly in the Me Too era now, called sexual assault. The federal government, and a lot of people thought this was the right thing for them to do, shut that loophole down, that essentially said you can't use that as a defense to the charge of sex assault, that you've drunk yourself essentially into a state where you commit that act. What a judge in Toronto has just done, and this is actually a big deal, is said, no, I don't care what the federal government says. I'm not prepared to take this potential defense, as rare or as often as it may be used, away from accused people. So from a defense lawyer's mind, I'm all in favor of it. But Beverly, I can tell you, if I'm on the outside or a member of the community, this is really concerning to me, given the proposition this stands for.
Yeah, and just to kind of drill down on that just a little bit, I mean, let me ask you about this. So the accused, let's say in whatever case this case, but made the choice to become high, to become drunk, beyond his or her own understanding. So what does it say about the choice to do that? Well,
I think it's twofold. The choice that he makes, and then the choice that the young woman or women involved don't make, which is to have their bodily integrity violated by men. And let's be honest, we're talking about men and women here in different roles, where men have drunk themselves into a skunk-like state or taken drugs. And, you know, while there is a valid argument I understand that you could get all wonky about, which is, look, if you intend to do something, why are you going to drink yourself or put yourself into a drug-induced state where you can't perform the act that you're charged with? That, to me, really strikes at the heart of what it means to be a citizen, what it means to be a morally appropriate person, where you can't run to court and say my impulse control is gone because I imbibed so many substances that rendered me incapable of controlling myself. I think that sends a bit of a dangerous message, Beverly, to women across this land, that somehow if an accused gets himself into this very window, which is so extreme that, and you can only get a pass or a get out of jail free card if you're in that extreme, that's just a very bizarre message to me. I'm not knocking the judge, because I'm all for keeping defenses available to accused. But, you know, you go back to what the federal government, Beverly, did to say, this is not something we're going to countenance in a society, particularly, Beverly, when we know the dangers of sexual consent issues when people are too drunk to either consent or form a decent basis to control their own urges.
Okay, so let me pick up from that. And just before I let you go, too drunk to control their own issues, could this, in terms of precedent, spread beyond a case like this to, say, drunk driving?
Well, drunk driving has actually, and this is a good thing, those loopholes have been closed, because we're talking in legal issues in terms of the idea of intent. I don't think for drunk driving, this decision will go there. Drunk driving is settled to be sort of a different fish, as much as we can discuss drunk driving. But what's important about this decision for people across Canada to understand, Beverly, this was done by a superior court judge today. That's important. It's not a lower court. So other judges who may sit on a lot of sexual assault trials across Canada may use this as precedent. And all I'm saying, which is very concerning, as much as I've discussed this today, is what message does it send to a young woman who goes to a party, may get drunk, ends up passed out on a couch, and somehow if she's violated and the accused has gotten himself into this state, he gets a pass? Again, very, very bizarre situation out of a Toronto courthouse, Beverly.
Yeah, really interesting, but great to get your thoughts on this. Thank you. Ari Goldkind.